Very good. So with now it begins the, I don't know how many we have already organized. The next, I suppose, webinar of the Spin-off Competence Lab. Welcome to all of you to this webinar within the Spin-off Competence Lab initiative in the framework of the Research You project. My name is Juan Ramon Real. I work as a technical manager for Research You at the University of Cádiz. And well, the Spin-off Competence Lab, in a nutshell, is an initiative conducted by and organized by this project, which basically intends to help researchers, and especially early career researchers, to turn their research projects into business ideas. For this reason, and with this objective in mind, we have conducted a series of webinars focused on matters of a very diverse nature, like business models and canvas, grant funding and equity, speculative design. You can watch all of our previous webinars on the YouTube channel of the CEO Alliance, precisely where this event is being live streamed right now. And with no further delay, I would like to introduce Justina Pawlowska, patent attorney from Gdansk, who collaborates with its university, with the University of Gdansk, which is a partner university of the CEO Alliance. And she will be talking, she would be explaining to us certain aspects of interest for researchers when it comes to intellectual property rights management and protection. Justina, welcome, and thank you very much for being with us today. The floor is yours.
Thank you very much for kind introduction. If you don't mind, I will start with sharing the presentation because I want to avoid any technical problems. And then I will introduce myself and make some short beginning. Just let me acknowledge that you can see my screen. Can you see my presentation?
Yes, we can.
Perfect. So according to introduction, I'm a patent attorney, and we are going to talk about intellectual property protection. I will use abbreviation IPR, and please remember this abbreviation. So before I introduce myself, I just want to kindly inform you that I am the only copyright owner, and all photo used in the presentation is only for the educational purpose and shouldn't be copied without permission of the author. And additionally, each uses not pursuant to the law will be treated as infringement of the rights. Of course, during the presentation in slide, I will use some others photos. That's why I would like to be sure that you understand that this is for educational purpose. And of course, in order to copy these pictures, graphs, etc., you have to receive permission of the author. So let me introduce myself. I'm Justina Pawlowska. I am Polish and European patent attorney and representative before European Union Intellectual Property Office. I just turn it off. I like this quotation. In order that you can see in the slide, in order to become a patent attorney, you need to have law and let's call technical, so scientific other than law background. And additionally, in order to be European patent attorney, you have to obtain technical education. So you need to be educated in technical science, particular for your profession. I have more than 14 years experience, and I'm very proud that I'm patent attorney. This is my really passion. So let me explain the schedule of our meeting. I like to make some introduction. So I want to that you go to the space of IPR, intellectual property protection. So at the beginning, we will make some introduction. I will show you the real case study from your field and from daily life field. Then I explain you the category of IPR, the definitions. Then we switch to talking about statistics, because I want you to know how many applications, patent application, then come to the patent office and in which region of the world. Then I explain you much more deeply what is the requirement in order to gain patent, so gain monopoly. Then I explain you the content of the patent publication. I try to encourage you to use patent database. Then I make some switch to inform you about exclusion and exception from patentability. We switch then in order because you will gain the knowledge, the basic knowledge. We switch to biotech and chemistry world, and then suddenly we go to very controversial topic: computer implemented inventions and AI. We finish according to the content, and we are going to talk about case studies, real case studies. If we will not have the time, we will do it during the next meeting. And of course, as you can see, you can ask the question. If you want, you can just interrupt me. I don't mind. I want to look at the chats all the time. So if you don't mind, just turn your micro and camera if you want, and ask me the question. Okay, I come back to my presentation. So first of all, the introduction. From what point of view we can think about IPR? Let's beginning from the businessman, entrepreneur, or daily user point of view. You can ask the question, can I produce such shoes that you see in the slide? Can I make something based on inspiration and not infringe? And finally, what and how can be protected? And this is the real case. You can see a Balenciaga pair of shoes. it look like this. Maybe you like it, or you don't like it, or you don't have any opinion about these shoes. But what happened after showing Balenciaga pair of shoes is it wasn't so it was expensive shoes. And suddenly French fry carton shoes. And McDonald's make some fun at the Balenciaga red square toed letter mules by showing the French fry cartoons being worn as makeshift slip-on shoes. And this was the inspiration. Of course, regarding the infringement cases, everything depends on the rights that you mention in the infringement dispute. But this was the real case, and this is the fun. So first point of view, can I make such, let's say, joke from this funny shoes? And that happened, and the fans of McDonald's, of course, like the page, etc., etc. And from the inventor point of view, I will show you some umbrella that I saw lastly. Okay. Let me wait for the... Yes, here you have, here you can see umbrella. I like it very much. It's very convenient umbrella because you can hang the umbrella very easily, and of course it protects from the rains. And of course, looking at such umbrella, you can ask the question, I want to be first in the market and make big money. I do not want my umbrella to be copied. And the questions is what and how can be protected. Is it expensive, worthful? And today we are going to talk about this matter. And from investor point of view, of course, the big question is it worth my money to invest on some projects, the results of research? And finally, can we see the goods protected by law, by IPR in daily life? And because you represent C research project, during preparing this presentation, I just I think that the case regarding the C technical solution will be more suitable to showing you the real case from this C field. And here we can see, of course, very interesting vessel. It's LEGO, the grandest ship, historical unveiled ship, and of course can be protected, this structure by LEGO. Of course, here we have some mark that means that LEGO is protected as name as such, but this structure as well. And here we have, here we can see the elements of the vessel, of the ship, and other kinds of such vehicles. And each part can be protected, for example, by patents, by designs, and additionally all structure of the ship. And this is the real examples. You can see the pictures from the drawing from the patent publication, and this is the real vessel, the real ship. And what happened? In early hours, 1944, Allied troops stormed northern of France. And this staggering logistical feat against Germany's army could not have success without the efforts of a shipbuilder from New Orleans. And she make the new construction of the vessel, and of course this construction was patented. And you see the publication date in here, and that year, in this year, everything happened and was much a success because of that kind of inventions. And here you can see another examples. Right now I'm showing you the first page of patent application, and here you have a short abstract from the patent application to understand what is protected or what is applied for patents. Here you can see the underwater vessel. This is a patent from United States, and here you can see the represented figures. So the construction, just shortly, some construction is protected. Another example is boat for excursion. So we have pleasure board, and according to the invention, the board comprises some bottom, and from the bottom there can be located gondola. And this is demand for the patent European in comparison to the previous examples. And another examples, gondola as such. So the previous one was the ship with the gondola, and here you can see another examples of construction that can be or is protected by patents, or for example a bullet for not only vessels but can be especially specialized for the vessel. And another example, seat board having a center wing and two slide wings, for example, European patents. And for example, some packages, some container that can be stored in the vessel and there can be some hazardous, so very dangerous material. In another case, I was really shocked. I will show you something regarding the field of the sea. There's real marine traffic, and you can see this traffic, and this is in live. So can you imagine how many vessels right now are found on some places of the world? So coming back to my examples, here we have examples of protected or provided for application invention relate to a vessel traffic service expert system that is based on deep learning algorithms. So we will not go into detail, but it's just explanation for you what can be additionally protected in this field. And of course, from the sea to the air, of course, all or airplane can be protected. The part of the structure, these vehicles, and additionally the whole structure. Of course, then there need to be met some requirements, but anyway, of course, it can be applied for protection. Another example is aircraft seat that is very convenient and useful for protected again turbulence. And this particular example is Lufthansa application. I'm not sure, I don't remember right now if it's patented right now or not, but anyway can be patented. And switching from the sea to the real daily practice, it was very nice conference that I was attended. It was in Dublin, and the co-organizer was European patent attorney. As you can see, I was wearing something. I just I want you to know that I like glasses, so you're supposed to see me in another one during the next meeting. And in here, what can be protected from this? Or let's say it's not me, it's some person. Shampoo composition. Some skirts of Dolce Gabbana or shoes of Dolce Gabbana or perfumes in this particular case. Of course, all presented name brands are chosen accidentally. And this is very important to note. Lafayette element of the clothes, watch, textile, fabric, stocking, socks, or even shoes. The structure of our shoes, or as you can see, the real example, it's Manolo Blahnik company and author of these shoes. I wearing this one, but it's just examples. Socks protected by designs, watch protected by designs, and additionally, as I saw you before, composition of the shampoo. This is solid one. I think that you are aware of this kind of composition of this kind of shampoo. And additionally, in here you can see the figures from the patent publication. And in here we have protection of the fabrics. That in the fabrics there are some micro-encapsulated active substances. And this here you can see the encapsulated substances, and this fabrics is also applied for gaining patents. So after this introduction, I just want to shortly summarize, summarizing because it's good to understand that there are plenty number of objects of IP and plenty number of tools that allow us to protect these objects. The object that I mentioned on the left side is just a general term, and embodiment of this term you can see in shops. So first of all, what can be protected? inventions, then utility models, industrial design, trademarks. Today we are going to talk about inventions, but I will explain you all definition of the main objects. Additionally, literary and artistic works can be protected by copyrights. And regarding inventions can be protected by patents, trademark by registration. So this is summarizing of what can be protected. And you will understand what that these symbols mean after the next meeting. So regarding law, according to law, there is division between tangible and intangible assets. And patents, logos, copyrights, or IPR set intangible assets. Intangible means not material rights. So here we have physical objects, and intangible assets means not material objects that can be easily monetized. And it's very important to know, to be aware that one product can be protected by different tools, so different law categories. And this is, in my opinion, good examples of logo bricks. First of all, it was patented, the structure of this bricks was patented, and as I will explain you later on, there are some limitation in time regarding patent protection, and it's 20 years from the date of application. And because Mattel, the company that, as far as I remember, the company that produced Lego bricks want to have protection by longer time, and additionally after or during patent duration, the company applied for design protection. So the red bricks were protected, and additionally the trademark. So the Lego is protected and was and is protected right now still. And because right now we are in changeable, let's say changeable worlds, so we can be in Metaverse. There are some prediction how many time we will spend in Metaverse, but because of the Metaverse, there are additional division of the assets. So as I mentioned before, we have tangible and intangible assets. And we have fungible and non-fungible assets. Fungible and non-fungible means if this particular asset has some particular value, and fungible has some particular value. Regarding NFT, I will show you on the next slides. What is it? It's non-fungible asset. And this is, let's say, it's something like equivalent of the patents or trademark registration. And NFT is non-fungible tokens that can be understood as a unique digital certificate that is registered in a blockchain and is used to record ownership of the assets. So far, a lot of things have such unique digital certificates. For example, sport leagues are where sport leagues was joining and provide trading cards, and additionally paintings. Some paintings can use NFT. We have some kind of metaverse, for example, FR and AR. The second one is something like in general in FR you need to have special equipment in order to join to this environment. And regarding augmented reality, so the second kind, it's not necessary to use a headset. Just this metaverse can be delivered through smart glasses, headsets, portable devices, or smartphones. And why I show you this matter? Because in the metaverse we can find protected goods. For example, incarnation of the human being, so avatar, can be protected. And of course, you can go to the metaverse and you can buy some goods, and these goods can be also protected. So there are possibility to meet infringement cases there. We will talking about this during trademarks and designs, but regarding patents, so today's topic, it can happen additionally. And of course, IPR play important role in gaining success. It's very important for the players, from the business players, to protect their rights in proper tools. That's why I am patent attorneys, so profession of giving advices regarding how to protect the rights in order to gain success. So it's very important. I like this quotation. So it's very important how to name your company, how to name your product, and what strategy of the IPR protection you will choose. And IPR, in my opinion, and some statistics confirm this, that it play an important role in making prestige, so create some loyalty between the provider and the customer. Do you have any questions? Okay, definitions. Invention, so the first IP object. It can be device, method, composition. We don't have a definition according to the law, but this is from Wikipedia. This is the Wikipedia that I think that it's real reflect the law purpose of the protection. And this is very important, that in order to gain patents, you need to understand that some inventions can be patented, and I will explain you later on about requirements of patentability. Trademark, it's the signs, words, just sign, regardless of the kind, that can use is used to distinguish the product from one company to the other. Designs means appearance of the product or part of the product. And the purpose of the IPR protection, it's, as I explained you before, again, intangible right that can be easy monetize. Items, products, etc., without permission from the patentee, so from the owner, is considered to infringe the IPR rights. So first of all, we have protection, we have monopoly. As I said before, the terms of patent is 20 years from the filing day. And additionally, in order to gain patents, there's some quid pro quo. You need to disclose your invention. That's why I will encourage you to use patent database and to understand patent publication structure, because these publications contain huge of knowledge that can be for you inspiration. So please be aware that use of other entity may result in lawsuit. And this is proper to all kind of IP rights. And regarding infringement of patent, it means that activity that is underlined is treated as infringe. So manufacture, import, use, market, production, selling, or even offering for sale. You can offer something and you can be treated as infringer. And the judge can issue some decision regarding infringement case. First of all, injunction, so stop use, award of costs, damages or account of profits, delivery up, destruction of infringement items. So this is real serious. And this is real example. So we have some settlement between Teva and the other one regarding pharmaceutical patents. And as you can see, the number, it's a big number of damages that was paid. In this particular example, it was settlement, fortunately. Or unfortunately, depending. The next examples of infringement is Starbucks versus Fredocino. So Starbucks trademark was Frappuccino. In fact, Starbucks bought this name from the author. As far as I remember, the name of the author was Howell. George Howell, yes, George Howell was first that name Frappuccino. It's connection of frappe and cappuccino, and of course Starbucks liked it and bought from the author, and there was dispute from the other coffee producer, because they start to use Fredocino. And because of the confusion between the trademark Fredocino and Frappuccino, there was treated as infringe. They were treated as infringement. So be careful, of course, be aware of infringement possibilities, and be aware of patent trolls. And patent trolls do not manufacture products or not supply services based on patents. Just look at the market and make lawsuit against entity that use the invention or trademark without permission. This is strategy of patent trolls. So the next part, statistic. I just shortly show you statistics regarding IPR in general. And this is WIPO, so worldwide statistics. You can see on the first graph, you can see trend regarding applications. So first of all, in order to gain patents, you need to apply for it. And application, as you can see from this graph, the number of applications have been still increasing regardless of the jurisdiction. So here we can see a European patent application, and in comparison in red we can see Chinese patent applications. And this is trend in patent grants. So the same, it's increasing. And regarding of jurisdiction slides, so China and USA is at the beginning of the statistics. And here you can see on the map geographically where there are a lot of application. So more red, more applications. And regardless of technology, of course, is changeable. The statistics can be changeable. And the same happen regarding utility model. The same happened with regard industrial design, so protection of the appearance of the products, and trademark. And the geographical coverage is similar in each categories. I really encourage you to see the statistics, because you can know and understand where some fields, when some solutions from some fields are protected. And this is the statistics of European Patent Office, and European Patent Office contain all this country. So this in red and in blue, it's a member of the European Patent Conventions. I just want to stress that not only applicant from European country apply for European patents, but in fact, United States, Japan, and China companies from their origin apply for patents and gain the patents. And of course, you can observe some technical fields, statistics, some trends that can be interesting for you. And you can also know which one applicant apply in general with the highest number, and in this year it was 2019, as far as I remember. Samsung was on the first list, was the first on the list of European patent application. And additionally, it's worth to understand that not only big entities apply for patents, but also SMEs, so short and medium entrepreneurship, and individual inventors. So you can apply. And the requirements of patentability. So first of all, I like this graph very much. And of course, the copyrights protected for the author or owner of the rights. So first of all, invention have to be novel, then non-obvious, and then marketability. So susceptible for industrial application. And this is the three main requirements in order to gain patents. And additionally, it's necessary that the patentable subject matter need to have some technical character. And because of the novelty requirements, it's good to understand that you can disclose your invention, show during the conference, in interview, but before it, it's good to contact with patent attorney, or you can protect by yourself if you understand, if you know how your goods, your entities, and then of course you can show it, for example, on Facebook. And right now we are going to talk about strategy, about procedures of patents, and I will explain you about prices. So first question, what do you think? Is it worth to protect in each countries? What's your opinion about this? Any idea?
We are having some comments on the chat. Some colleague is is answering that yes, she thinks that it might be necessary.
Okay, so it's clear, yes?
Yeah.
Okay, very important to cover the whole countries in the world. Sometimes, yes, that's why we have nice procedure that allow us to do in easy, let's say easy way, but sometimes it's good to plan the strategy more suitable for particular fields. And this is real example. It's publication from the European patent application. And can you guess what is it? What is shown on these pictures? Any idea? It's some robot. And the robot, it's a camel jockey player. So a robot that allow to use camel for sports. And this sport is very famous in Arabian country. And in this particular case, it wasn't worth to protect whole world, but only, for example, in Arabian country. But sometimes it can happen, maybe very often, especially for pharmaceuticals or computer inventions, to protect as many countries as possible. So we have three main procedures approach: national routes, regional routes, and international. And this, the last one, it's allow us to protect, to gain protection in almost or each part of the words. So national, you apply, for example, for patents in Korea or China separately, in Poland, or from your place of origin. Regional routes, I will show you one of the regional routes, but we will start from international. So this is PCT. It's abbreviation, but it's good to understand that PCT mean international application. And the blue country cover, the blue countries are PCT members. So by applying for PCT application, you can gain protection in this region, and you can choose, you can select part of this region if you want. So this is very convenient procedures that allow to protection. Regarding the price, for only the fee, the official fee, for PCT application for starting the procedures is about 5,000 euros. But after sometimes you need to put some money in each countries. So right now it's very difficult to calculate. So for example, regarding each part, each countries, it's about at the beginning 2,000 euros. And if you gain patents, you need to pay patent year by year in order to make it in force. So it's not cheap fun. But of course, the statistics show us that it is happened, because at the beginning we see the worldwide statistics, because you have monopoly, 20 years of monopoly. And I will show you the real case studies that confirm that this is worthful. And regarding regional procedures, it's a little bit not so expensive in comparison to PCT procedures. And it's good to remember that European patent application cover not only European Union countries, but additionally, and it change year by year. Year by year, new members go into this convention, European patent conventions. And the first fee for application is about 4,000 euros, depending of the volume of the application, of the pages. Do you have any questions regarding these procedures? About prices? Am I answer the questions? I will look on chat. You are quite shy. You should turn your microphone. The prices, yes, it's true. Regarding, can you hear me?
Yes, we can hear
Okay,
you.
perfect. I am afraid sometimes, because right now I see the questions. I haven't seen it before. It will be better that you will just turn off your micro and ask. But anyway, regarding the questions, yes, sometimes universities have a discount. Depending on the procedures, but it's true that everything depends on the entities, and additionally depend on the language of applications. So coming back to my presentation, I just want to mention that there are two very important points during patent lifetime. So first of all, you have time up to 1 year if you want to geographically widen your application. So for example, you apply for national procedures at the beginning. You are looking for an investor, and after found them, you apply for PCT application. And one important point is 18 months from date of filing, and after that time we can see the publications. And this is the next step, so patent application. As I showed you before, the requirements is for patent gaining is novelty, non-obvious, and marketability, so susceptible for industrial application. And additionally, there is some quid pro quo, so you need to disclose your inventions very deeply, so detailed description. So one way of carrying out the invention shall be shown. At least it's of course depending of the field. And I really encourage you to understand the patent applications, patent publication, and use a patent database. That's why I decided to show you and understand you this part. So we have some front page. I saw you the front page. Then the specification. So should disclose the invention clearly and precisely. So we have some examples, embodiment. You saw that there are some drawings. And the heart of the patents regarding the monopoly, it's patent claims. In patent claims, we have features that are in monopoly. So if you will use the inventions according to the features disclosed in claims, it means you infringe the patents. But because of requirements of describe your inventions very deeply, in the description, so in the examples, you can read something about inventions and understand it much more in comparison to the claims. So if you look for inspiration, I encourage you and recommend to read the descriptions. And of course, because of the novelty and non-obvious requirements, you have to include novel and non-obvious features in the claims to not cover to not cover the solutions from the state of the art. So there must be at least one other features not known. And regarding looking at the patent database, of course, me as a profession, as a patent attorney, I make some analysis based on patent database. First of all, state of the art. If somebody asks me what is known, then patentability analysis. If somebody asked me, can I gain patents or trademark registration, and FTO, so freedom to operate analysis. So if you want to know if when you launch some products you will lead to infringement, it's good to first of all make some search in the patent database and then compare your invention to the other, or you can use patent attorney services to know if you go to the circle of the claims. And just for examples, in here I put claims regarding Levi's shoes, so pantaloons. So you can see that the language is a little bit strange, weird, because first of all, it is just one sentence, and patent attorneys, good patent attorneys, try to disclose the inventions in general in order the others will go into the circle. So trying to use specific words that cover many other terms. And another examples, here you can see, just look at the first point, a very famous game tools. So here you can see the apparatus for make fun. So you are the football player, and there are two game players, and have fun to use it. And this was protected by patents. Patents, it's British pronunciation, and patents more American style. So you can see that it's really general and weird language, but it's very important to have huge monopoly. Of course, you need to include novel and non-obvious elements, features. Okay, so the structure is very easy. So regardless of the jurisdiction, so if it's European or PCT application, we can see the same on the very first page. So we have application number, date of publication, date of filing. So you can calculate how many years patent can be in force. Here we can see inventors, representatives, so patent attorneys, and abstracts, title, and representative patent applications. Patent publications are very important because there are some quid pro quo. So you need to disclose your invention, and the structure is similar. So in front page, we can see applicant name, inventor, abstract. So you can read the abstract, see the represented figures, and understand and know if you want to go later on. And additionally, I try to explain that the claims, so the range of monopoly can differ from jurisdiction. So for example, you can apply for European patent and gain protection in other monopoly in comparison to this one, so United States. And this is PCT, so international application, and the system is the same. So I stop on this slides, and if you have no questions, I will explain what is excluded from applications. So of course you can apply for process, machine, article of manufacture, composition, or improvement of any others, but some discoveries and scientific theories are excluded from patentability. So you cannot patent a discovery. The same with mathematical method as such. I will explain this topic much more deeply regarding computer implemented invention. Aesthetic creation is excluded from patentability, but you can obtain design protection. The same scam rules method for performing mental acts and for playing games is excluded from patentability. So here you have in summary, what is excluded from patentability. And in here we have programs for computers. Of course, it depends on the jurisdiction. It's just according to European Patent Convention, but it's quite similar. But computer programs, it's the most controversial topics. And I will explain you that some parts, so program for computers, not as such, can be protected. And we have additionally exemption of patentability. So there are invention, but anyway of this, it's exempted. So for example, invention that are against order public and morality are excluded. A set exemption. For example, process for cloning human beings. What else? Process for modifying the germline genetic identity of human beings. Regarding using of embryo, it's set exemption where the invention directly produce it's based on exclusively obtained by a method which necessarily involved the destruction of human embryos. So all parts are going to that destruction. Okay, so some checked questions regarding ord public. So the example of the invention that can be in order against the public order. What do you think? Can a patent be obtained for a claim directed to a process for breaking open a locked safe? So can be used by thieves. What do you think? Can you protect and apply for such inventions? I have something in chat. Yes, of course, because it's offensive and non-offensive use. And the same is regarding the second question. So when there's some offensive and non-offensive use, you can apply and gain paid patents. But what about the third one? Letter bomb. Letter bomb. You can't, because it's offensive. It's only offensive. There was some case regarding oncomouse. So was transgenic non-human mouse that was used to study pharmaceuticals against cancers. And it was much dispute if it's could be or should be exempt from patentability. And right now, this is measured by weighting the suffering of mice, genetically modifying mouse, and to benefit. So whereas the benefit is weighed much more, the patent can be obtained. Additionally, plant or animal varieties are not patentable, but here you can see the list of patentable biotechnological inventions. So first of all, material which is isolated from the natural environment can be produced. So natural products, but isolated from the environment. So where's some plant and animal variety, but not variety. So the other general term. Microbiological technical process that lead to other than variety, because variety is exempted from publication. And in fact, we have something like evergreen patents in pharmaceuticals. So you can, for example, protect receptor enzyme with impact on pathology, then screening method for that particular compounds, kits, interaction compound that interact with the receptor, and modify compounds. You can apply for first medical use and the second medical use, and the first one mean that some substances that can be used as pharmaceuticals, and the second medical use when you find some specific group of disease. You haven't seen it.
Very good. From my side, I can only say again, thank you very much, Justina, for your interesting presentation. It is indeed an essential part of every business, of every endeavor, so to speak, for researchers trying to get business ideas out of their research projects, to know about intellectual property rights and intellectual property protections, not only from the point of view of an academic, but for the professional who needs these tools to bring into completion their goals and ideas. So thank you very much. Thanks as well to all participants, to all attendees. As usual, attendance certificates will be delivered in the next few weeks. And of course, as Justina has remarked previously, on the 25th of January, the second webinar, the second spin-off Competence Lab webinar on intellectual property protection will be held. You've got all the information about it on the ResearchU webpage that we will be linking to the chat right now. Bea, could you do that, please? And well, in the meantime, I can only say once again, thank you. And would you like to say any few words to end with this session, Justina? Or
thank you very much. Sorry once again. It was very much my pleasure, and thank you, organizer, for it. That it was my pleasure, really. So please do not hesitate to contact me if you have any further questions. And see you during the last meeting in 1 week. Thank you very much.
fantastic. Thank you very much, Justina. Goodbye to all of you.
Bye.
It's been a pleasure.
Have a nice day.